Hello and welcome to the latest edition of the Data Privacy Party installment. Let's get started. Hey, what's up, y'all? Happy to be back here. I know it's been a while since our last edition of the DPP installment, and so looking forward to talking to you guys again. It's been a busy couple of months, and I apologize for being out, but I'm happy to be back with you guys today, talk a little privacy news. Some may be slightly dated, but I want to bring it up because I think it's very important to just have that top of mind, especially as we get closer to a lot of these state privacy law updates. But real quick, life update for me. You may be wondering, those of you watching YouTube, why I'm wearing this shirt. It doesn't look like a traditional shirt that I usually wear, but I just got back from Greece not too long ago. Had a lot of fun with the family and friends, being over there just on vacation. Took nice 2 weeks off. First time I've taken any time away from work since January, and that was barely a week long. So this was a nice 2 weeks that was needed. And so me and a couple other family and friends ran the Athens Marathon and completed it. That was kind of a big goal we wanted to do back in 2020. 3 years later, and another marathon later, me and them finally ran it just as a fun thing. Well, fun, maybe a bit of a stretch, especially for those of you that aren't big runners. And I might not necessarily call myself in that category per se, but it's just fun to do hard things sometimes, especially with other people. And so those of y'all listening, I just kind of encourage that something physically difficult for you that might not be a marathon, maybe that's something a little further, one of the 50-mile races out there. For some of you, a 10K might be physically difficult. And so, everyone's obviously at different levels. And so whatever that physically hard thing might be, I'm definitely a big advocate for trying to do at least one very physically difficult thing every single year. But without a doubt, or without another update to give you guys, I mean, that's kind of the most fun one for sure. But let's get back into it. So looking forward to chatting today. Big state privacy update. A couple months ago, Delaware passes their first state level privacy law. And so this one has a couple of similarities to some other ones we've seen kind of come through already. And we'll talk through some of the main ones. And I'll have the links to the law in the comments on YouTube and on the podcast notes as well. But Delaware's law is HB 154. So this one's been passed, signed by the governor back in September. Like I said, it's been a while since we talked, but this is the most recent one. Right now on the horizon, New Hampshire looks like the one that's going to be signed next. I think that's just waiting on a signature, but we'll talk about that later. Delaware effective January 1st, 2025. So a lot of companies that do business out of Delaware, work with Delaware citizens, you got a little while until you got to get yourself in shape. But that January 1st, 2025 date will be here in no time, roughly a year and 2 months. The applicability threshold, we see that there is not a revenue threshold attached to it. At least you can find one in the text. So this one mimics some other data privacy bills we've seen. Texas comes to mind. There is no revenue applicability threshold. It's in or you're out sort of thing with state consumers. The other one, the data broker threshold, is one that's common, and we see a lot of different states have different levels. So kind of a lot of that's just based on population, wanting to kind of be a similar percentage of it. So Delaware is going to be if you process the data of 35,000 or more consumers within a calendar year, or if you process the data of 10,000 or more consumers and derive 20% of your revenue from the sale of that personal data. So fairly low. A lot of that has to do with the population of the state, and I'm actually not sure what that is off the top of my head or how it compares to the other laws we've seen. Some of these others we've seen up to 50,000, some even more than that. And so this one just kind of is accounting for the population of the state of Delaware. Controller and business obligations. your standard, limited collection, allow access to data, allow consumers to opt out of the sale of their personal data, allow them to request to delete, allow them access to that data to correct it, give them confirmation that it was corrected, that it was deleted, so on and so on. So not discriminating against them for exercising their rights. These are all things we've seen with other laws. So if you're already doing those based on other state laws, you're going to be in great shape. Same thing goes with privacy notice requirements. Sorry, y'all, talking fast. Listing out the categories of data you process, who the third parties are that you sell to, or at least the categories of those third parties are, contact information for the controller, the categories of data that get collected, and the purpose for the collection of that data. And then if that data is disclosed to any third parties as well, just standard stuff that we've seen across other state laws. And these next two that I'll chat through probably won't surprise you either, but the safeguards are required, just like in every other one. Administrative, physical, and technical safeguards. We've seen these across a number of different regulations kind of referencing these guys. If we look at Sarbanes-Oxley and how much work has been done around various operational and technical controls and administrative and physical as well, a lot of those can be used in the same way. It's just a matter of what's being protected, what's the control doing to protect. A lot of times with SOX, we're talking financial data, but with HB 154, and the other state privacy laws too, we're talking personal data. We're not talking financial data. So slightly different applicability. I would say probably the same controls is likely already applied to the personal data, but it's just a matter of, honestly locating where that data is. I think a lot of companies doing a data discovery exercise is what they need in order to apply those controls consistently to the different systems and areas in their organization. Lastly, the violations. There's a 60-day cure period. Enforcement by the Attorney General, of course. No private right of action. No citizens can take action against others. All goes through Attorney General. If there's a violation found, the organization gets a 60-day cure period in order to fix said violation. If the violation is not fixed within that 60-day period, or is just perpetually violating the law, then the penalty, which it doesn't specify a number, at least I couldn't find one. I would imagine it's anywhere from $500 to $7,500 just because of some of what we've seen in other state laws, but that's going to come directly from the Delaware code that is, what is a constitute an unfair trade practice and the violation accordingly with that. A lot of times it's going to be per violation. So, you violate 100 customers' data, $5,000 per violation. That's going to add up, and it's not going to be very pretty. $500,000 is not a very fun fine if you are trying to avoid paying as much money as possible. But nonetheless, those are kind of the updates for the Delaware privacy law, and hopefully you can take measures to prevent it. Next two topics, we're just, this is just general increasing privacy litigation for companies. So I'll talk about three, actually one of them being larger than the others, but targets are often the consumer facing companies, the targets of litigation. So we're seeing a lot of litigation come up recently, especially with the states that have already enacted privacy laws that came into effect this year. Virginia, California being two of them, and Colorado too. I think, I can't remember. There's just so many, and they just keep on coming. But let me grab the chart real quick, just so. Okay, apologies. Yeah, okay, Colorado and Connecticut. I was actually missing one of them. Both those came into effect this year on July 1st. So a number coming through next year, getting close. I mean, I'll actually talk about it at the next podcast that we do, but just the states to be aware of that are going to be coming in 2024 and the dates. We've already talked about all of them in the previous episode, so feel free to refer back for those. But jumping into litigation for companies, there's one case, Javier versus Assurance IQ. This was a 2022 case that's was about consenting to a website session recording technology, which cannot occur retroactively. So giving consent to be recorded for your activity on a website has to be done prior to interaction, not after the interaction. Recording occurred before consent was given by the consumer, so organization is found to be at fault in this instance. So this kind of it basically saying, after I obtain information on you, do you consent to me obtaining information on you? That's just not the case. Or not how it's supposed to be. That's definitely something that would be considered a violation. Next one is Papa versus Harriet Carrier Gifts in 2022 as well. The plaintiff, Papa, alleged unlawful wiretapping was being done, interception of the conversation. So party to a conversation can be held liable for its own interception or eavesdropping on in violation of Pennsylvania's Wiretapping and Electronic Surveillance Control Act. So Harriet Carrier Gifts was listening in conversations without providing notice that this was happening and allowing consent to happen as well. So I think a lot of companies have been, as we've kind of moved into a big data, big collection sort of environment, market, ecosystem, back in the early, mid 2000s up till now, it was just collect as much as you can. Don't worry about, consent or anything. There weren't really too many laws in place. And now that these laws are coming in, we can see, a lot of times legislation doesn't keep up with innovation. So now this is finally, we're seeing we're seeing legislation finally catch up, 15 years later after innovation, 15, 20 years. This next one, big one. So there's a $23 million settlement with Google after a 13-year legal battle over Google's users' PI that was provided to publishers. And so the federal judge approved a settlement on Thursday. This was back October 12th on Thursday. So almost a little over a month ago, of this class action lawsuit. So what happened was that Google transmitted search queries of users to publishers, some of which contain personal information. 2.5 million claimants expected to receive approximately $7 each. So a rather large class action lawsuit, netting you about $7 each for that. It's funny, I had I'll call him a constituent, inform me they used to work at Google, and part of the job was to try to figure out how can we still sell information even though you've already opted out of selling that personal information. So essentially, how can we sidestep around? And then, according to what they told me, the court case, Google lost, and so they ended up losing their job because of it. Rather, it just, at least Google puts the money where their mouth is. They're still in the game of collecting and selling data. They do a good job of both, I would imagine, at this point, but we'll see how much longer they can keep that up as a lot of these laws start to get on the side of consumers and not necessarily big tech companies. All right, down to getting to chapter 5. So usable and useful privacy interfaces. I'll try to kind of go through this one pretty quickly with y'all. I encourage you to read the Intro to Privacy Technology textbook from IAPP if you're looking to obtain your CIPT certification. So, and a lot of this I'm kind of just going to read off for the most part, but we're talking, to begin the chapter, one of the big components of it is user-centered privacy by design. So why is that such a big deal? This is done to meet legal obligations. So we already talked about a couple different court cases today that resulted in a loss by the organization and a win by the consumer. This could have been avoided had those companies taken a user-centered privacy by design approach. This puts the needs and the values of the user at the center of the system's design. So not only does it meet legal obligations, but it also, constructs the system and the various privacy components to operate as if the user is the main part of that design process. The system doesn't work properly without proper safeguards in place. An example of this would be using predetermined options instead of allowing users to input free response to an online form. A very simple example. Rather than asking people to specify their income, just give them different predetermined options, or rather their age. Just say, are you below 21? Are you 21 to 29? Are you 30 to 39? Just kind of giving them these big boxes of their age ranges rather than making them put in a very specific age range. Next major topic would be privacy, decision-making, behavior, and concerns that this chapter talks about. So it introduces something called a privacy paradox, which is that people expect high levels of privacy from the technology and the systems they use, privacy protections, yet their behavior doesn't reflect that expectation is there. I expect, for instance, Facebook to do a really good job of protecting all of my personal information, yet I post on Facebook location of where I am, I post a photo somewhere, the time of that photo, who I'm with, kind of an entry into my own personal life is put out there for everyone to see. So it's kind of like I said, a paradox. You're sharing information freely on social media, yet you expect the social media company to protect that information. Behavior is often not completely rational. Who would have thought? Markets are irrational. Human behavior is irrational. And we often act on impulse, but a lot of times on a risk-benefit analysis of the situation. To me, sharing a photo of a trip I went on does not constitute as much risk as the benefit that I get from it. Whether that benefit is you want more likes, you just want to show friends what you're doing, whatever that benefit might be, it outweighs whatever risk that you took into account before you posted that information. So, this same analysis, like I said, it happens when someone is told to give up information about themselves. So this is now more so from someone is asking me to give up information I'm not freely giving up. So that, almost feeling in less control. So someone's asking, okay, where did you go for vacation? I, maybe less willing to give up that information if someone's asking for it rather than to freely provide that information to the world if no one's asking for it. And I encourage everyone that might be listening to kind of think about that too, because we may be more inclined to give up information if we feel like we're doing it freely. And this is getting in more of a philosophical debate, but we're more inclined to give up information freely if someone is not asking for it, if we feel as though we're doing it under our own free will rather than someone demanding that from us. And this is where a dark pattern may come into play, where they're kind of manipulating your behavior through various questions and other things as well that come through. But moving on to our next one, there's a concept called usability and user experience. So just to quickly touch on this one, there's 5 factors that go into this that I highly encourage you to know going into your exam. That is, one is learnability. So you accomplishing things on your first try, and you kind of understand what you're doing. There's not much teaching that needs to go on. Terrific concept. Efficiency, how quickly can you perform the tasks? Memorability, how easy is it for you to reestablish what it is you're doing? You log in, go add stuff to your shopping cart. That's a pretty easy thing. A lot of us know how to do. Use Amazon or any other online store. It's pretty easy and you remember how to do it. Errors, what are the total errors and the severity of those errors that you make? So if you click checkout before you're done, is it easy to go back and, cancel that purchase, get a refund, or are all sales final once you click the button? How difficult is it? What's the impact? And last one is satisfaction. That's just an obvious, like, hey, was I satisfied with the product, with the experience? More so the experience in the product. You're definitely going to be satisfied by the product because you want it, but how easy was it to buy that product? Was the experience seamless? To an extent, it's so seamless you almost don't even feel like you're spending any money because it was just so fast. There's companies out there that do a good job of this now, trying to take advantage of the instant gratification sort of behavior that a lot of us consumers have nowadays. Next part is called design of privacy interfaces. So we talked a little bit about this already. You know, those 5 factors of usability and user experience definitely play a huge role in how privacy interfaces get designed, but then this takes it another step further. And not only is it easy to use, but how often do you get reminded, or how informed are you when you're making these various decisions? So how many privacy notices come up? Are these reminders? These are information as you're going through what's happening with your information. How's it stored? How's it going to be processed? How's it going to be retained? And do you get consent options? So each instance, and what are they like? So there's different ways that this comes up. If you is it let me say, one time at the beginning you consent to sharing information, or does it occur every single time you're going to input personal information? It asks you to consent to inputting that personal information. You know, one is real time integration is the one where it comes up every single time there's a spot where you need to input new personal information. Does it consent? Privacy settings. So are the users able to modify after they've done something? Maybe you make a mistake and you click yes, share all, versus you just want to share with a limited amount. How easy is it to go find those settings, make the correction? Are dashboards available? You can see what it is you're sharing. Companies use dashboards. They know exactly what they are. You and I probably use a lot of dashboards too in our daily lives and our work lives. You know, how easy are those and how available are they to the user as they're going through their privacy experience with your system, your site, and so on. An interesting stat. So in the European Union, a survey of over 6,000 organizations had privacy policies that were over 3,000 words long. And in their professional opinion, that was considered way too long. If it takes a high school, you know, the most recommended from various experts, most recommended pieces of copy, you know, interviews, whatever, speak at approximately a higher elementary level reading level, you know, 5th grade. I would even say late primary school, early secondary school sort of level. Anything above that starts to get a little too complicated and people start not understanding what's going on. I mean, in the case of Facebook, with their user agreement, got, you know, absolutely destroyed a while back by Congress just because it was so complicated and it contradicted itself, and it was just so overlapping that it got to the point of someone feeling like they needed a high school education, or sorry, a PhD level education in order to understand it. Now, maybe that probably is a little over exaggerating. I personally have not read it, so I don't know. But it was just way too long and way too convoluted is what Congress was trying to make there. This last part, so this is building privacy interfaces with a 6-step process in privacy by design. So this is what I'd like to leave y'all with, and I'll remember to add stuff into the chat as well, or the show notes and on the YouTube. So this process should be kind of a baseline and modified as needed based on where you are, where you work, and who you work with. But to start, ID requirements and build from a privacy assessment. So conducting that privacy assessment, what data is the most critical? What is, you know, based on regulations, based on what we do as a company, where's that stored? What controls are around it? And then what are the requirements that you need to have implemented in order to do it, whether it's personal policies or whether it's legal obligations. ID users and their privacy needs. So who is it you collect data from? What are those different criteria that need to be done based on state laws, you know, privacy notices, obligations of controllers. Excuse me. We talked about some of those earlier with Delaware's privacy law. The next one, number 3, ID unexpected data practices. And so obviously nothing's going to go according to plan every single time. So what is it that someone could do with the data that gets collected that we probably didn't think about? You know, for instance, we're an example I'm trying to think of off the top of my head, maybe someone obtained precise geolocation information from a set of users with their income, just to kind of gauge, how much money does someone make, but then someone uses that to kind of gauge the price of housing in that area. It's a kind of a silly example, but it's one that data was used not for the intended purpose. It was used, to gauge what housing prices might be, just based on income level, rather than whatever the original purpose was going to be. You want to integrate your privacy framework now into your user experience. So now that we've ID'd the requirements, the users, unexpected data practices, and the controls, how can we add those controls into the user experience? Where does consent come into play? Or do we allow a lot of free response forms, or do we do a lot of drop downs? Do we kind of make it so that the user's giving us categories and buckets rather than exact information? Number 5 would be to leverage the available design space. So we don't necessarily want to redo the entire design. That would be very silly, a lot of work, a lot of lost resources in what was already been built, but we want to build off of what's already there. A lot of times, unless you're just starting literally from scratch, there's going to be no room to just rebuild. That's going to take way too long for companies that have been around for 50 years, that have been building for the last 50 years, just to have to throw it out and do something entirely new. No, not saying do that. You need to kind of build off what's currently there and build onto it in the most effective way. And lastly, number 6, obviously conduct user testing. See what the user experience is like with your end users, figure out exactly what it is that they are looking for. What do they need to be doing? What are they, how's their data being protected as well? And really focus on, if this is user-centric privacy by design, then a lot of these tests should run very smoothly, because we've already incorporated consumers and their needs into the beginning of our design process. And so now whenever we develop and then implement, it makes it a pretty seamless process, especially at the very end when you do the testing. Consumers know what to expect. They are comfortable with it. It goes back into, the usability and user experience 5 factors we talked about, and also the design of privacy interfaces that we talked about earlier. So that wraps up. This was chapter 5, usable and useful privacy interfaces. Hopefully that content was good for you. It's all very important. There's still more in the book. I don't recommend using this podcast for your studying, but I do want to provide kind of a high level, what should you know, and what do you need to be doing in order to prepare for your CIPT. From one CIPT to another current or another future CIPT, and being able to provide y'all with as best information as I can. As we conclude up, I mentioned earlier, the next privacy bill up is New Hampshire. We'll probably kind of talk a little bit about that one next week, and I'm sure it'll be similar to Delaware. I haven't had a chance to look at it yet. But the next show should be our final one in December. So what we'll do, I'll look back at my predictions that I made at the beginning of this year and recap those, see how close I was. And then we'll also look at what privacy bills are on their way. What do we need to be expecting in 2024? Because there's a lot that are coming through in 2024. It's wild to see, we've gotten a lot of these that wrapped up in 2022, 2021 with a target date of 2024. And now we're almost in 2024. We didn't didn't think Virginia would come so soon, yet here we are, 2023, Colorado, Connecticut. A lot of these are going to be in place. Time flies whenever you're having fun, especially in the data privacy world. So with that, look, happy to be here again with you guys. Hopefully you learned something new today. I encourage you to study the CIPT. And I'm glad if you use this as a resource to at least get a high level understanding of what it is and updates on the latest privacy news. So until next time, y'all, please continue to keep researching more and more privacy topics. Feel free to check us out at dataprivacyparty.com and subscribe to the newsletter. Always love feedback as well. Leave a like, subscribe to the YouTube or podcast, Spotify, Apple as well. And until next time, thanks for listening to the latest edition of the Data Privacy Party install. Hope you learned something new and can better protect your information. Like us on YouTube, Apple Podcasts, and Spotify, and subscribe to hear more great content.